Okay, I'd like to welcome you to the May 19th, 2022 meeting of the Zoning Hearing Board of Radnor Township. If you'd like, please join us as we do the Pledge of Allegiance. Pledge of Allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. First, I'm going to ask, we have, I believe, an extension request or continuance request, which is a little out of order, and we're going to just deal with that first. It's application, appeal number 3129. Could the applicant step up, please?
Hello, how are you?
Good. How you doing? What can we do for you?
So we, my neighbor and I are working on an agreement that's related to this project.
I'm sorry, what your name?
My name is Miguel Pena.
Miguel Pena, okay.
My property's 400 South Wayne Avenue.
Got it.
So my neighbor and I we've been collaborating over the last several weeks, and we've made some progress on coming to an agreement that we think could resolve his opposition to the project.
Okay.
So we'd like to request a continuance this evening and request that we get scheduled for the next zoning board hearing.
Yeah, well, two things. As part of that, we would require you to extend any deadlines that are imposed on the zoning board or the township regarding this matter. And also, I'm not sure about scheduling. I guess it depends on how much we have for the June meeting already.
Yeah, so the deadline has passed. I believe we have three. The two that continued or that had to get extended because of the length of the number of appeals, and one or two more that were submitted. So we three, maximum four. This would be a fifth, fourth or a fifth.
All right, so it's likely it'll be the June meeting. But any questions or I'm sorry,
Yeah,
Cameron.
if there's an outside chance, we're going to do our best to try to come to an agreement prior to the June meeting, or actually the deadline for submittal, which I believe is the 3rd.
Correct, it would be the 3rd.
Yeah, so we're going to work hard to meet that deadline. There's an outside chance that we don't. If we, would it be okay?
You'd have to come back for another continuance
With the
and request another continuance.
Okay.
If you're on the June schedule.
Yeah.
Okay.
Yeah, I was just wondering if we could, on the 3rd, if we could then just let Mr. Kachansky know that we're going to need to push to July.
Yeah.
Can we do it that way?
Mr. Kachansky, yes.
Okay.
So we would not need to come back in June if we didn't make that deadline, as long as we notified.
Yeah,
Mr.
you wouldn't. He'll forward the request.
Okay.
Perfect.
Should be returned. Yeah. Any questions for anyone? Okay, so we're going to grant a continuance. Good luck with your discussions.
Great. Thank you very much.
Thank you. Okay, the next, we'll go back in order now. Appeal number 3122, the applicant William Heron and Gabe Lau, property located at 1106 County Line Road and zoned R5 residential. The applicant is appealing the zoning officer's enforcement notice dated December 6, 2021, which relies on section 280-35.A1 and 280-131.A. The relief requests include the relief requested includes variance by estoppel, equitable estoppel, laches, application of the vested right doctrine, and alternatively, a request for a variance. Is the applicant here? Get you in 1 minute. If you could introduce yourself.
Sure. Good evening. Chris Hinderleiter on behalf of the applicants, and with me is Gabe Lau, one of the property owners.
Okay, Chris. Now, you realize there's been a motion filed to quash your application?
I do, and we did respond to that and argued a couple things. One, that there were some defects in the enforcement notice, and two, that we are moving forward with variance requests, which are not affected by the 30 days of the enforcement notice.
Understood. So we're going to hear any arguments on that motion first, and the township will go first in their presentation.
Thank you, Mr. Chairman. John Rice on behalf of the township. As the chairman stated, the township, Peter Nelson from my office, submitted a request to quash this appeal back in February 8th of this year, based on failure to appeal the notice of violation, which was issued on December 5th, 2021, until the 31st day. It's clearly beyond the 30-day appeal period. The notice of violation set forth the 30-day appeal period. The case law is clear. The statute is clear. This board, we believe, has no jurisdiction. If you file it a day late or 30 days late, there's no jurisdiction on an appeal like this. So that's simply our argument. Today, we've received a response. February, March, April, May. 3 months later, we received a response. And counsel for the property owner is attacking the violation notice. And he cites to a case. And if you read that case, what that case says is that in that particular situation, the township had the wrong zoning district and never cited to any of the provisions in the zoning ordinance. That was the basis of that decision in that case. Clearly a defective violation notice. And that, I think, is a 1994 Commonwealth Court decision. I think that's Berks County, Maiden Creek. And that's been the law since. So the township and Mr. Kachansky are very careful about what goes in the notice of violation. All the elements are in there. It's clear that they're in there. His violation notice, which is dated December 5th, spells out in a lot of detail. First of all, it cites to the correct zoning district. It cites two specific violations, 280-35A1, 280-131A. And after inspecting the property, he gave the applicant 10 days to submit plans and permit applications and an application to the zoning hearing board. Within 30 days, it says clearly, you have the right to appeal this enforcement notice to the Radnor Township Zoning Hearing Board. You must file this appeal within 30 days of the date of the issuance of this notice. So not only was the appeal filed late, but they never filed any permit applications for any of the work. And I don't want to get into the merits of this, but I think you've seen enough back and forth that essentially this property owner put a second dwelling unit on the second floor. But you don't have to even get to the merits because they haven't filed the appeal on time. Mr. Kachansky's violation notice describes failure to comply with the notice within the time above constitutes a violation unless an appeal is filed. You should take this action immediately. Respond to me in writing within 5 days. So I understand why the property owner wants to attack the enforcement notice, but that has to be done in 30 days too. All of that has to be done within 30 days. It wasn't done. We're asking that the board quash the appeal. I have Mr. Kachansky here who can testify as to the enforcement notice, the filing of the application, and I have a couple exhibits if the board wants to hear those, you know, to make a record in this case, and he's prepared to do that if it.
Do you have a copy of the enforcement notice?
I do.
Okay.
I do.
Do you have copies?
Actually, I have 3 exhibits.
Okay. Why don't you submit them?
Mr.
Yeah. Let's submit them. Yeah.
First, it's just a summary of dates.
John, make sure that you're on microphone for record, please.
Here's one you can walk around with.
I bet if I don't talk.
Okay. Thanks.
So what you have in front of you, Mr. Kachansky, I may an offer of proof in terms of the testimony, but you have his timeline. Down the left side is Monday, December 6th, the enforcement notice issued. Then what happened on January 6th when the appeal was filed? A couple emails to me about the submission, and then on January 6th. And then on January 18th, a FedEx package from the applicant, which, because the January 6th filing was incomplete, so we received the rest of the required application material on January 18th, and it was still missing some information. And then the board authorized my office to attend and oppose the application. So that's what I'll say is T1. T1 is a timeline of the application, the enforcement notice and the application. T2 is the enforcement notice itself, which I stated at the outset, sets forth, the zoning district sets forth the specific ordinance provisions, and in bold letters advises the applicant that he has 30 days to file an appeal. T3 is the letter that Peter Nelson from my office sent, dated February 8th, 2022, which, again, recites the history and cites to the applicable statute and some case law regarding what happens when a statutory appeal period is missed. And what happens is the appeal gets quashed. I mean, there's very, very, very narrow circumstances where that doesn't happen. There's a great Latin word, nunc pro tunc, that if, notwithstanding that I missed the appeal for this reason, usually an extraordinary reason, like a tornado hit the courthouse, there has to be something just extraordinary for that appeal period to be waived. That didn't happen here. We've had ongoing enforcement issues with this property and this property owner for over a year and a half prior to the application. And so that's the township's position. That's my position on behalf of the township. We think it's clear. And if the board wants to hear from Mr. Kachansky, he's here to talk about T1 through T3.
And, John, let me ask you a question. The zoning ordinance violation in question is the minimum lot area requirement for the
Yes.
property that is approximately 10,800 square feet for a two-unit dwelling
Correct.
unit. Yeah, okay.
Correct.
All right.
And then there's a permit requirement in the code for, any alterations.
Right.
I mean, this was sent after Mr. Kachansky inspected the property and did a walkthrough.
Understood.
George, can I ask a question?
Yes,
Sorry.
go
Is the township's position then that, because at least in the introduction, it talked about a request for a variance, is it the township's position that the application as a whole should be quashed? Or
Yes.
is it just related to the appeal of the zoning enforcement?
Yes. And it's typical on an appeal from an enforcement notice. You contest the enforcement notice, but you also ask for alternative relief, but you still have to do it within 30 days. That doesn't extend the statute at all.
So, Mr. Rice, if the applicant came in tomorrow with a complete application for a zoning permit, he would be permitted to do that? There's no, I'm not a litigator, res judicata or anything like?
There is some res judicata in zoning law. It's relatively flexible. I would take the position that he's precluded from doing that. He had an opportunity. In fact, he had two opportunities. He filed an appeal 6 months before this appeal was scheduled, and he withdrew it. Basically the same issues. And, that, again, and that was from an enforcement notice also. So when you don't appeal an enforcement notice, the case law is, that's a conclusive determination that you're in violation of the zoning ordinance. And that's been the law, Johnson versus Lower Macungie, since like the mid-90s. If you don't appeal, and that's grounds for equitable relief for the township. We've done that, where folks haven't appealed clearly an enforcement notice, and that's the next step.
But is the failure to timely appeal the enforcement notice dispositive to the question of whether the applicant would ever be permitted a zoning variance if they came in with an application tomorrow and filed an application, notwithstanding the prior violations? Is there anything precluding them from filing a variance application tomorrow?
I think the issue is going to be there hasn't been a determination. They would need to file for a permit, get denied, and then file for the appeal, then for the variance. So they have, if they want to pursue other steps, they can't come today if we quash.
Well, I'm not going to make the argument.
Yeah, I mean, I don't,
You can't. They haven't filed a permit.
if they come in to file another zoning hearing board application a month from now, we'll have to deal with it. You may have to schedule a hearing, and I may be back here telling you that res judicata or collateral estoppel applies. So that's their call, but, you know, we're at the point where there's clearly been ongoing violations. You know, we have information from the prior owner about what's on the property. He's an attorney. I know him. He will come and testify. I didn't tell him to come tonight because I didn't think we'd be getting to the merits, but there's a lot of testimony as to what's happened there. What's going on the second floor? It's an apartment, from what we can tell. So, but anybody can file a zoning hearing board application, then it becomes, you know, Kevin's issue, and I'm not sure it can be kicked out, you know, based on that. We probably have to come back here again.
Let me ask a question on this. As I understand what the applicant has asked for by way of a variance, it's all based on an equitable argument that would justify, if granted, would justify the variance. Is that right?
I
mean,
believe-
vested interest?
Yeah, they vested rights, equitable by estoppel.
Yeah. It's really,
there-
it's an equitable type of application that they're asking for. Now they're actually in violation of the zoning.
Right.
So wouldn't they have to clear up those violations before they could apply and assert some equitable claims? You know, do equity before you can ask for equity?
I don't want to speak for the property owner,
Right.
but,
Are you see, yeah, to me, I'm here, are you asking if there's unclean hands? Is that
Well, that
where
would be,
you're-
you know,
the violations are
in other words, to
still
John's
exist.
point, that could they just come in the next day, tomorrow, and file the application? I don't think they can, because there's a presumption, especially since they were cited as far back as October 20th, and then withdrew the appeal, so that at least on that particular, there's clearly established a presumption of in violation. They would have to clear the violation before they should be able to come back and make an argument that they're entitled to some sort of variance.
But I think they're going to make the argument there is no violation. So for them to fix the violation, they would have to get their permits. They would have to remove the second dwelling unit on the second floor. They'd have to take it out, put it back to a single-family dwelling, which is what it was, under the prior owner, and get all the permits. And then we'd be happy with that. Township would be happy. That would solve the problem. They don't want to do that, obviously.
Well, I guess I think this is the argument I'm hearing, and I'm finding a hard time understanding it. If the applicant, you know, they violated, there's an enforcement complaint, they violated the code, they pay whatever penalties they're supposed to pay, they then they apply for a permit to do what they want to do, and it gets denied. At that point, they can never, ever in the future request a variance from a zoning ordinance?
They may be able to. in the future. I mean,
Why wouldn't they?
I don't know.
Okay?
But that's, I don't think is in front of this board tonight. Tonight is, you know, you have enough specific enforcement notice, you have a failure to appeal it in a timely fashion. And if they want to do something down the road or fashion some other type of application, you know, the township will deal with it when it comes through the door.
Okay.
I have one more question. You touched upon it, the nunc-pro-tunc aspect. Do we as a board have that ability to consider an equitable remedy like that? Maybe that's a question for Gus.
Well, you mean with respect to missing the deadline?
Yeah.
Assuming you make
Do we
that
have the right-
determination?
Assuming, I don't even know if that's in front of us.
That's what I mean, I don't even know that
But
request
if
has
the
been
arguments
made
were
to you.
raised.
I mean,
would we
yeah,
have-
you could, but if someone that made that request to you, but I don't know that it's been made yet.
Right.
But I was serious when I said it has to be like a meteor hitting it. I mean, it's an extraordinary happening that prevents somebody from meeting the deadlines. It's just not equitable. Breakdown of the court process is one,
I understand.
and that hasn't happened, nor has it been alleged.
Any other questions? Okay. Thanks, John. Chris, some reply?
Thank you. And first and foremost, I disagree that the enforcement notice contains all of the required provisions. Sure. I disagree that the enforcement notice contains all the required provisions. And it's not a flexible standard with respect to the enforcement notice. Mr. Rice wants to talk about inflexible standards with respect to one day in one direction or another, and wants to talk about inflexible standards with respect to nunc-pro-tunc. But what he failed to raise was that the section that's applicable, 16.1C, contains shall language, and it shall include all of the requirements of section C of that, subsection C of that section of the statute. And in this case, it's missing one very key component, which is required by C4, and that being the date before which the steps that are laid out in the enforcement notice must be completed. You can look at the enforcement notice and not see that anywhere in the notice. And that was glossed over, I think, but it's clearly not in there. And the steps for compliance that were laid out talk about, in the first sentence, within 10 days, please submit the appropriate plans and permit applications for all renovations completed at the subject property. And thereafter, it says, in addition, an application to the Radnor Township Zoning Hearing Board will also be required. Nowhere in there does it satisfy the requirements of section 616.1C4, which include both the beginning date for compliance and the end date for compliance. And it's shall language, it's required, and the case law, and I believe this was agreed upon, the case law requires strict compliance with that. And if the enforcement notice does not comply with the statute, then enforcement actions cannot continue and cannot take place. So that's first. Second, I disagree with the argument that you can't have alternative avenues of relief. The application to the board that was submitted in this case clearly requested a variance in addition to appealing from the enforcement notice. And that request for the variance is not subject to the 30-day time limit that the statute talks about for enforcement notices. And so it's our position that the variance hearing and the request for the variance should be considered, and it should be decided on its merits.
I just noticed one thing about your request for a variance. All it says in your application is, and alternatively, a request for a variance. It doesn't tell us what you're asking for. Variance from what? I assume it's the section regarding the
Sure.
minimum lot size, but
Sure, the lot
we
size.
don't have anything to go on here.
Right, and perhaps could have been worded better, but certainly there, it was a request for a variance from the lot size.
I have a question. If you wouldn't mind being a little more specific in terms of that first argument,
Sure.
meaning that the MPC requires the date on which
Sure, yeah, and.
it should be completed by and
Yeah.
the
it's-
beginning date of the violation. That's where I'm a little confused.
Yeah, I'll read the section of the statute to you. It's C4. It shall include the date before which the steps for compliance must be commenced and the date before which the steps must be completed. And it's a strict standard. It's required to have those things in it. And I can contrast one of the exhibits that we would submit as part of the variance hearing is an enforcement notice that was directed to a prior property owner, a prior owner of the same property. And I'm trying to find the exact language right now. And in that one, it specifically says, this is an enforcement notice from November 9 of 2012. It specifically says that you have until December 10, 2012 to complete compliance. And that was also signed by Mr. Kachansky. And so in prior enforcement notices, the township was able to satisfy all, this particular section, subsection C4, by specifically spelling out the date by which they had to complete compliance. That's not going to be found anywhere in the December 2021 enforcement notice. It's missing.
Well, let me rephrase my question then. Can the date before which the steps for compliance must be commenced and the date before which the steps must be completed be the same?
I don't.
In other words, if I give you 10 days and my notice is issued December 6th, isn't December 16th the milestone for compliance to commence and complete?
I understand the question. I think the distinction that we're making is that there's two steps for compliance that were being requested in the enforcement notice. First step was to submit plans, and that one had a clear 10-day deadline. The second one was to submit an application to the zoning hearing board, and there was no discussion of a deadline for completing that compliance in the enforcement notice. And they're disjunctive. They don't. There's no discussion of when the second piece of that compliance needs to be completed. There is a specific discussion of when the plans need to be submitted. And so that's the distinction.
The one, on the second page of the notice, enforcement notice, final paragraph, it says, respond to me in writing within 5 days acknowledging receipt of the enforcement notice and stating what actions you have taken or will take within 30 days to bring your property into compliance with the zoning ordinance. Doesn't that satisfy C4?
I don't think it does.
Well,
No.
why not?
Because it's a request for a letter to say what plans do you have are you going to take, but it's not a discussion of what is a deadline to complete compliance. What's the deadline to actually submit the application to the zoning hearing board?
Did your client respond to Mr. Kachansky within the time period that was requested in that paragraph I just read to you?
With respect to sending a letter with a plan?
What I just read to you, respond to me in writing within 5 days acknowledging receipt of the enforcement notice and actions you have taken or will take within 30 days to bring your property into compliance. Did he write that letter? Did he
I don't believe
communicate with Mr. Kachansky as requested?
I don't believe that letter was written, no.
I have a couple of questions about the requirement in the enforcement action that a application be made to the zoning hearing board for a variance. So helpfully in red language, there's the within 10 days, please submit. In addition, an application to the Radnor Township Zoning Hearing Board will also be required. So those are the two things that have to happen. One, the first sentence has the 10-day language in it. The second sentence does not. However, there's language further in the enforcement notice that speaks to having failure to comply with the notice, here are the consequences, yada, yada, yada. Unless an appeal is filed within the Radnor Township, with the zoning hearing board, within 30 days of the issuance of this notice. So doesn't at least that put the applicant on notice of the types of time frames that are expected for compliance under the enforcement action?
Well, I believe that complies with a different subsection of the statute, which would be C6. So it's not the same requirement.
But the first mention of a filing with the zoning hearing board is in the same paragraph that talks about 10 days and submission of plans.
It does, and conspicuously doesn't give a deadline for it.
But I think I think that to argue that the applicant's not on notice of when they have to take action and what they have to do, reasonable minds could differ on that. Let's just put it that way.
Well, I don't think it's not an equitable argument that we're making. The township's making a bright line one day argument about when an appeal has to be filed. We're making a bright line statutory language argument about what the contents of an enforcement notice need to be, and about what the contents of an enforcement notice need to be. And so I think there's some hairs being split here on both sides, probably. But if the township wants to split hairs on one day, then I think we're entitled to split hairs on what is the precise statutory language and what does it require to actually be in the enforcement notice. And so that's the argument that we're making.
Good, thanks.
Is the word date defined in the MPC?
Is the word date?
Yes.
Off the top of my head, I don't know.
Because you're arguing that a date is May 18th, May 19th, as opposed to 30 days from today. Both are dates.
Understood.
So obviously in general contract law, and when something is ambiguous, you can just go to the dictionary.
Sure.
And one of the definitions of the dictionary is the period of time to which something belongs, a statement of the time of execution or making, which clearly is not reflecting May 18th. At least Webster's is indicating to me that it could mean 5 days from today is also a date. So again, I'm just trying to, in your mind, a date means May 18th and nothing else.
I actually don't. I don't understand the question. I apologize. I think the only point I'm trying to make is that.
But you're arguing today because the notice says 30 days from the date of the issuance. It clearly says that. You know what the date of issuance is, and you know it's 30 days. You're arguing that in order for that to be accurate, it would have had to said January 5th. And that's the only way that they could have complied with this notice.
No, that's not the argument I'm trying to make. The argument I'm trying to make is that the red letters, the red language in that enforcement notice is what lays out the two things that the townships is demanding for compliance. And there is a date for the compliance in terms of submitting the plans. There is no date indicated for the second piece of the compliance that the townships are demanding, which is the filing of an application to the zoning hearing board. That's the argument I'm making.
So you're arguing that the fact that the sentence says you have the right to appeal this enforcement notice is not covering everything that's in the letter?
I think that's covering a separate section of the statute. And there is a principle in the law that that statutes are not written with superfluous language. If they had wanted to only include subsection C6 in the statute, then they would have only included that. But they also included C4, which requires both a beginning date and an end date for the compliance period.
Any further questions? I had one.
George.
Oh, John, sorry.
Just one quick item. So the argument we're hearing is a rather lawyerly, split the hair, use a scalpel on it kind of argument. But it also seems very disingenuous, given the previous answer, when you were questioned about the fact that the request for variance did not contain any specificity. So that it's very inconsistent in my mind, and also, as a non-lawyer, a reading of this notice to me is clear as a bell what the deadlines were.
Thank you, John. I just had one other question, and Chris, this might be for John or for Kevin possibly, but we've heard that the appeal was filed January 6th, which was one day after the deadline. Was that hand-delivered? Did you receive it in the mail? Do we know that?
I hand-delivered it.
You hand-delivered it? Okay, on January 6th?
Yeah.
Okay.
And at that time, Mr. Kachansky and I talked about there was a couple missing pieces, and he graciously said, send them in before January 18th.
Got it. Okay, thank you. Any further questions? Thank you, Chris. I think what we'll do we're talking about the motion to quash the application. I would like, and for purposes of getting a discussion, I will make two motions. I will split this out. The first motion is that we grant the motion to quash regarding the enforcement complaint appeal. And I guess I'll need a second on that. Okay. The second motion I will make, and we will discuss this after we discuss the first motion, is we will grant the motion to quash regarding appealing or asking for a variance from the zoning hearing board. So that's, they're split out, they're two different things.
Would you repeat that again, please, that last one?
Do I have to?
Oh, darn, I'm sorry.
The second one.
Why don't we read it? Can you read that back?
Yeah. No, the second one is, my motion is to approve the motion to quash the request for a variance from the zoning ordinance.
Thank you.
I'll need a second. Okay, so discussion on the first motion.
Well, I'll start. When I read over, I mean, we just saw the notice. I mean, I have never saw the notice, enforcement notice before. It was just handed up by John Rice. And I looked at that, and I looked at section 616.1 enforcement notices and all these sections, and I looked at this again. I think this complies, and I don't. You might get down onto a huge debate as to how many angels can dance on the head of a pin, but this complies. This fully informs the landowner of the nature and extent of the violation and what the landowner's got to do to straighten it out, and they haven't done anything.
Yeah.
So I would think that it should be quashed, and the thing is that we don't have the authority. Unless, as John said, there's some extraordinary event, like the entire system broke down and the applicant did everything they could to get the thing there on time, and it didn't work out for reasons totally out of the applicant's control. And it's highly unusual, but once those 30 days passes and the citation of the law in the letter from the township attorney is correct, we're bound by that statute and we lose jurisdiction. And without the jurisdiction, it's an exercise and a waste of time to proceed further on the matter. So that's how I feel about it.
Yeah, and so it's clear what my position is for the record. I'm not interested at all in the substance of any of the arguments as to the validity or invalidity of the enforcement notice because the appeal is not timely.
And any other discussion, board members? Okay, we'll have a vote. If you're in favor of the motion, that means you're approving the motion to quash on the enforcement complaint appeal. Brad? John?
Aye.
Rich?
Aye.
John?
Aye.
Also in favor. The vote is 5-0. the motion to quash on the enforcement complaint is approved. Now we'll move to the second motion that was made regarding the ability to apply for the variance at this point in time. For my own purposes, again, as I earlier stated, I certainly think that the applicant would have the right to do that. Brad, you raised an interesting point that, well, they haven't applied for a permit yet, and so there's nothing to react to, because the action hasn't been taken yet. I guess my only concern about that, and I'm looking at the actual notice, and again, back to the red lettering, and this is from the township, and it says, in addition, an application to the Radnor Township Zoning Board, Hearing Board, will also be required. So that kind of suggests that the township did take some action that's appealable to the zoning board, because they're saying it right here. You have to go to the zoning board to appeal. So if there was no action taken, why would they ever say that? Because you wouldn't have to go to the zoning board. So that's my take on it.
Yeah, George, I would agree. I think the notion that there hasn't been a determination is misguided. The application might be defective for any number of reasons, and I suspect we might get to that. But to say that there hasn't been a determination with respect to the compliance with a set of circumstances with the zoning law would, I think, is just a mistake. So I certainly don't feel that the applicant is precluded from submitting a full and complete application to the zoning board for whatever variance request, or variance relief, the applicant might seek to obtain. I'm not certain, well, I don't know how far into a proceeding we should get if we know that the application package is deficient.
Well, John, I appreciate the distinction you made, but my response to that is that he was still beyond the 30-day period within which to bring the matter to us. So I still don't think we have jurisdiction, even if we, and I think I agree with you, I think that's a determination by the township with respect to certain rights that he did or didn't have. But he still had 30 days to appeal, and he's still late.
But the 30 days was for the enforcement notice.
30 days was, yeah, that's right. The 30 days was for the enforcement action, not necessarily the period of time during which the applicant could exercise its rights to request for submit a request for variance relief from the provisions of the code. Which is why I asked the question earlier, could they come in tomorrow and submit a zoning application, a variance application? I feel that they could, because I don't think a finding that the appeal or the challenge of the enforcement action has any sort of res judicata effect with respect to our subsequent consideration of a complete application for zoning relief.
But isn't that application due within 30 days of the township's determination? No, I'm seeing heads shaking.
I think it's, I don't know the point in time by which an applicant might not want to file for a while and change its mind and say, you know, I really want to pursue this particular project. It could be months down the line. And then they come in and submit a zoning application, knowing what the response to the permit request was. They could still, I mean, I don't know that, Kevin, is there a deadline by which, if the determination is made that you need variance for that extra 5 feet of family room you want to build, do I have to submit a request for a variance within 30 days? No. No.
But your question presupposes you're not in violation.
Yes, it's the issue.
And they are in violation. So imagine the scenario where we say, okay, fine, we'll hear your we'll hear your application before they cure the defect. Let's just use that language. The defect is the fact that they are in violation of the township zoning ordinance. Full stop. They could, file for their variance. Sure, you're right. They could file anytime. They just didn't. Let me finish. They didn't file within the 30 days. But they've got to cure the violation, or otherwise they can carry on the variance application all through the courts. It could be months, even the way things are going to the courts. Let me tell you, it could be years by the time they get to this. Meanwhile, the neighbors in the area have to put up with a violation of the zoning ordinance that's probably affecting them, or maybe it's not. But it renders meaningless the fact that they are in violation. So they should cure the violation before they can come back and put in the application for a variance.
I think we should be dealing with the facts on the ground in this case and not a speculative, they could do this, they could do that.
Well, your
We
question
have
asked the same thing. Could they
Now
come
let me
back
finish.
tomorrow?
Now let me finish. We have found that their challenge to the enforcement action is untimely, which means they now need to comply with it. Now, filing a zoning application prior to complying with that enforcement action might not be the best idea in the world, but I don't know that it's not permitted. And that's the distinction I'm drawing between what is permitted. They have a couple of decisions to make. The first of which is how they're going to comply with the enforcement action. Secondly, they have a decision to make as to whether they want to pursue a variance.
I think one of the ways to look at it is that they were informed, I think very clearly by the enforcement notice, that they were supposed to submit a zoning variance at that time. They blew it. They didn't make it. They destroyed our jurisdiction over this. Can they come back later and reapply? Of course they can. Of course, in the meantime, the township is free to invoke all of the fines and other things that they can do, bring an action in front of the DJ or something like that, I suppose. They can do those things because it's the right of the township because they're in violation. What I'm suggesting is that this is a package, and they were directed to file a variance, for a variance. They did not. They didn't do it within the 30 days. I don't think they get get a bootstrap and just ignore the 30-day requirement because we don't have any jurisdiction. And what I would like to avoid is us dealing with this because it's a very interesting question, the types of variances that they're asking for. Having it go up to the Court of Common Pleas in Delaware County, and if they ever get around to ruling on it, rejecting it because we didn't have jurisdiction, because right now we don't have jurisdiction.
Mr. Chairman?
Yes.
Yeah, hopefully I'm going to help clarify things a little bit. Hopefully the board's not conflating whether or not you decide a variance tonight. You can't grant a variance retroactively. So just because this is entangled in an enforcement proceeding, I don't think that because if you consider a variance tonight, and there may be plenty of reasons for denying it or granting it, but that's up to the board to decide. But the fact that there may be, in the past, violations, and at this point, if you've quashed the appeal of the notice, they're now, as of now, a determination that they're in violation, as of a certain date, going back in the past. But that's separate from any variance application that they may have filed on January 6th. You may have a basis for denying it, even denying it preliminarily. A board member here can make a motion to deny the variance application for deficiencies before you hear any argument. That's a separate issue. But even if you heard a variance tonight, it wouldn't do anything for the applicant retroactively. It wouldn't do anything. It wouldn't eliminate the violations that, as of tonight, there's a determination have occurred.
Well, at least on my own behalf, that's not what I was concerned about. That it was applied retroactively. It's the fact that they were directed to submit this within the time frame of 30 days. The case law is very clear on the point that we lose jurisdiction, it's game over. Now, that's not to say that they can't come back once this is all cleared up and out of the way in terms of whether we have jurisdiction or not, and apply again.
But your jurisdiction with respect to an appeal from an enforcement notice has nothing to do with jurisdiction for a request for a variance.
Well,
They're completely separate.
It does if it's part of the enforcement notice. That's the point that we're not, look, no case law, nothing has been presented to us so far to tell us that you can carve that out, carve it out. Right now, we're looking at an application, an enforcement notice that said, among other things, submit a variance. Didn't happen. So if our, you know, it's, in a way, it is not a way, but it's a part of the enforcement notice. I don't know how you separate them out. I'm just erring on the side of caution because they can come back and file for a variance at their leisure. There could be some, you know, implications in terms of the amount of fines and so on that might be charged. I don't know what they are, but they must be out there someplace. But it might just spur them to file that sooner. But at least we'll know we have jurisdiction over that because there's simply no question that we would. I'm talking about a new application.
So, John, you had asked Kevin a question, and we shifted gears rather quickly. I'm curious to hear the answer to that, if you don't mind.
I'm going to need to hear the question again.
I think
I was afraid you were going to ask that question.
it's to the effect of, is there a time limitation within which an appeal for a variance has to be made after a determination that one's needed?
If I determine that a violation has occurred, an enforcement notice is issued, and there is the time procedure spelled out in the enforcement notice to which to comply. It is typically 30 days.
And what about on the variance side?
Well, in the variance, if it's a preemptive, you know, so a homeowner wants to come in and construct an addition prior to, you know, putting a shovel on the ground and actually putting the addition up, there's no timeline. They're pre-planning it. They are being proactive in looking at their lot, looking at the improvement, determine that relief is needed. Those applications come in front of this board all the time. Most of the cases, it's not me issuing an enforcement notice or a determination.
Right.
It's, you know, an agreement, yes, you're in violation of the code, or your proposed project would be in violation. Hence, if you want to proceed, you need to apply for a variance. In this case, we had an ongoing violation, so it was retroactively.
So and I think that's right to John's point, but it's not, in other words, I apply for a permit, you say that's not permitted, you need a variance to do that, and then I take it to the board.
It can proceed that way. Most of the appeals that are in front of this board are a homeowner or their design professional understanding the code and the limitations of the lot, and then saying, okay, if you want to proceed, here are your options.
Understood. Okay.
And Rich, one other point, not to belabor this too long, but the enforcement notice itself prescribes what the consequences are of failing to observe the requirements of the enforcement action. So if we're taking the red language as prescriptive, as we should, those things didn't happen. We've made that determination. Neither a timely appeal nor a timely application for zoning relief was submitted within 30 days. The enforcement notice then describes what the consequences of that are. $500 a day, court costs this, that, and the other. Doesn't say you lose the right to ever submit a zoning variance application. If the township thought it had that power, presumably it, would consider putting it in there. Rather punitive, but, if they felt they had the power, they could put it in there. But the consequences of the violation are laid out in the enforcement action. And to start arguing that a property owner has lost a right to submit an application for zoning relief, I think goes beyond what we should be talking about.
Well, let me just be clear. I'm not saying that this acts as a prior restraint on a property owner's ability to go and apply for a zoning, put in an application for a zoning change. I'm not advocating that at all, where he's forever banned, for the rest of eternity. That's not what I'm suggesting. I mean, that would not be enforceable in the least. It's unconstitutional. There's a lot of things wrong with it. What I'm saying is that technically they did not do what they're supposed to do within 30 days. And one of those things was to put in an application for a zoning ordinance. They didn't do it. We don't have jurisdiction over this thing now. But that's not to say they cannot put in an application for a zoning approval at a later date. And the clock starts again, and then we would have jurisdiction. They're not going to lose any rights. They're not going to be harmed in any way.
So then we get to the question of whether the non-timely appeal of the enforcement action, coupled with a generic request for zoning relief, constitutes a new zoning application on the day after the compliance period. And
What do you mean by generic?
the generic request for zoning relief in the appeal that was filed,
Well, it's a very specific, it would be very specific. They'd have to file an application for a zoning that would allow them to continue to use this property as they have altered it without a building permit.
the applicants asked for zoning relief, correct?
Yeah.
In an untimely manner.
Yeah, just to kind of state the obvious here. We do have an application in front of us for a variance from the zoning ordinance. We have the application, they filed it. So that's happened already.
Actually-
I will add another thing. They have asked for equitable relief here, which means we're outside the normal rules about granting variances. If we were under the normal rules for variances, I'd have to deny this because there's nothing in here that we can make an informed decision on. All they're doing is asking for a variance. What section? I mean, there's nothing here. But they're not asking for the typical type, or they don't have to meet the hardship requirements and everything else you would need for a regular variance. They are arguing an estoppel argument. And if there are facts to support that, then they'll be successful. So it's a different approach in this case, and I just wanted to make that clear.
I guess the only thing the very first sentence, it's an appeal from the December 6, 2021 enforcement notice. While the rest of the language speaks to relief, I don't know.
No, it's a good point. Yeah.
Yeah, to me, that first sentence sort of defines the nature of the application in front of us.
And to me,
And the reasons why it should then have been granted.
the notice is 100% consistent with that. When I read the notice, when I read the application, I thought it meant the same exact thing, which is they're only asking for the board to hear the enforcement notice issue. And some of their arguments under that will be these estoppel arguments and variance. I don't think they're saying, by the way, here's a new application, I want you to hear it on the merits. I think the notice and the application were strictly on, I'm going to defend myself against this enforcement notice. So I don't think we have the ability to actually grant a variance because I don't think we have anything in front of us that is even talking to a variance other than, again, inconsistency with the request. I think the relief that is requested both in the application and the notice is strictly towards the enforcement action and nothing else.
Right, which means we
don't have jurisdiction. I really think we should err on the side of caution. Instead of having the case go up to the Court of Common Pleas in Delaware County and then you get told, well, you didn't have jurisdiction to do what you did, and the applicant is not losing any rights. We didn't preclude the applicant from exercising any right that a township resident would have. They can come back, they can file their application for a variance, and the clock starts running, and it will be dealt with in time in the normal course of events. It's a cleaner, safer approach, I believe.
Any other comments? I should ask, is there any public comment?
Well,
This is on the motion to quash.
Right. The only thing I would add to what John just said is, to me, I think I'm in agreement with John's argument, and in terms of trying to avoid res judicata for the applicant, really all we're voting on in the motion is that we don't have jurisdiction with what's presently in front of us, which is an application that says what it says.
Any other discussion? Well, board vote on, the motion is to approve the motion to quash on the variance request. So if you're approving this motion, they will not have the ability at this point in time to request a variance. Brad? Aye. John?
I have an issue with the motion. I'm sorry. Okay, fine, then, I'm going to abstain. I'm not sure that there is a motion to quash the zoning application, but I'm just going to abstain.
Okay. That's okay. John? You're in favor of the motion? Okay. Rich?
Aye.
Okay. I'm against the motion. I think there is jurisdiction here. It's an equitable request. So I really think that is a different analysis on these issues. But in any event, the motion passes 3-1, right? Which means there's no request tonight for a variance, and I think you should proceed with alternative solutions. But thank you for coming. Thanks, John. All right. No, it's not 29. All right. Okay, the next application, well, we did 3129. Appeal number 3134, the applicant Larry and Bianca Valente, property located at 312 Rockingham Road and zoned R4 residential. The applicant seeks relief from section 280-30D of the code to add a front porch that will encroach 8 feet into the required front yard setback. Is the applicant here? Please come up.
Good evening. So
Good
we
evening.
have a house that. Yes. Oh, I'm sorry. It's Blanca, B-L-A-N-C-A. My last name is Valente, B-A-L-E-N-T-E.
My name is Larry,
So we have a house that we owned for the last 44 years, but we have not lived there for the last 30 years. We would like to move back, so we want to make some renovations. And one of the things that we looked in the neighborhood is like most of the houses that they're doing, they have this little front porch. And I would like to have the front porch, but they said that in my case, I'm going 8 feet in, you know.
in the front yard.
Yeah, on a front porch that's going to go 8 feet into the required front yard. So we are asking relief for section 280-30D. We are no lawyers. I mean, this is what they told us.
Okay, thank you. Can you take us through your exhibits and explain what they are, and maybe we should number these? Which exhibit would you like to start with?
Well, we gave you the architectural drawings.
Yes, we'd like you to explain them to us and what they show and what you're asking for.
It shows what we are going to do. We haven't done anything. Like I said, the house is empty right now. We would like to start, you know, renovations.
Do you have a copy of your?
No.
Do we have an extra copy anywhere of their materials?
There should be 2 in the file, but you want, let me see.
I'll let them borrow it. We'd just like you to take us through the pictures, explain what's going on.
Sure, I'm sorry. This is our first time.
Understood. Thanks, Kevin. I think, yeah, one's bigger than the, yeah, one's just a,
So if we start also, if we start with the pictures, they told us that we needed to take pictures of the houses near us, you know, on both sides. So
Okay.
that's the
Okay,
very.
so this package of pictures, what do we want to number this? Just A1? Yeah, there's one, I have 1, 2, 3, 4, 5. Is there 6 pictures?
Yes.
6 pictures. So
The
that group
first-
of pictures, we'll call A1?
A1 will be the picture, it will be the house to our right.
Okay, so the first picture is not the house in question.
No, it's not.
It's
It's the house to the right of our
just an
house.
example of what the neighborhood looks like and
Yes.
what other people have.
Same of this, let's call it A2. The next picture is the same thing. It's another view, but of the same house. A3 will be the house in question. That's our home.
And
It's-
I'm sorry, do you live there now, did you say?
No, we do not.
You're just moving back?
Yes, we would like to move back.
Got it.
A4 is again another view of the house that we would like to remodel. A5 is the picture of the house to the left, same as the A6. So they told us to take pictures, so we did. Okay. So,
And your house has the street on the front, the park is behind
yes,
you?
we are in the park, yeah,
Okay.
yeah. The park is behind us.
Well, let me ask you a quick question on these pictures. So if I'm looking at A3, that's your house, and you're proposing a porch coming off where your front door is there over those bay windows?
Yes,
Will it be similar to the porch on your neighbors, A5?
yes, yes. Yes, similar to that. Not exactly the same, but very similar. Yep.
Okay, okay. Okay, we'll call that, that plan A7, I believe.
Okay. So the first, I believe that the first picture you're seeing is the existing house as it is now.
Yep.
So. Oh, there's another microphone, but I don't see the changes are in the small one. If you look at the other set of pictures, because the very first one is this house as it is now. The second one is the proposed renovation. Oh, I'm sorry. I didn't see that you guys had that. Sorry. Okay, I wasn't. Okay. So we're in page number 2, right? So it's difficult because, you know, it's a split level, you know? Mhm. I know, but it's difficult for me to see it. So I'm trying to understand here. So bedroom 1, bedroom 2, and bedroom 3 is exactly as it is now. We're not doing anything to that. Then there is a bathroom. The bathroom, the only thing that we're going to do, that's the existing bathroom right now, because we would like to eliminate and then in closets upstairs. So on the renovation. There is, I'm just going to see the wooden deck is old. We want to redo the wooden deck and just replace it by another wooden deck. There is an existing family room there. As you can see, there is a very small kitchen, living room, dining room. So that is what it is right there. And then the picture at the bottom is the existing, I call it the basement, but it's a split level, so it's above ground. So you can see that there is a small laundry room, a garage, there is a small den, there is a half bathroom, and the crawl space. And that's how it is. So here is what we propose. In the new lower level, we would like to eliminate the garage. You can see that we would like to add a mudroom in the entrance in the bottom. We would like to make a bigger bathroom. So So the garage and the existing family room becomes like a bigger family room. That's the wooden deck, crawl space, nothing there. Then here, you can see in the middle, again, bedroom 1, bedroom 2, and bedroom 1 and bedroom 2, nothing happens here. What used to be bedroom 3, we would like to make it a laundry room.
Yes. Bianca, I think we're probably most interested in the porch, but that sounds like an excellent plan you have.
Okay, I thought you wanted, so you
Yeah.
can see it here, is the porch, is the
Thanks.
thing in the front, that seems like it's going 8 feet, over the required, yard, front yard, and we would like an exception.
Are there other houses similar to yours in the neighborhood that have added a porch like this over the years?
I have a bunch of pictures in my phone, almost every other house in the neighborhood. It's like, there is about 4 blocks, all the homes are the same. I'm not sure if you're familiar with the area. This is in Rockingham. It's just a park, and they're all split levels, and most of the renovations have done the same thing.
And have you had any conversations with your neighbors about the proposal? Has anyone either been, supportive, or they had questions or concerns, anything like that?
Very supportive, actually. 3 of the neighbors that are there used to be our old neighbors, so we already talked to them and we told them, and they seem to be happy that we're going back.
And then, front of the page looks like there's some sketches of the proposed porch, is that correct?
Well, that's the back, that's already there, that's the deck that's already there.
Page 8-2.
I'm sorry, where's the page number?
At the very bottom right. Very bottom.
Yeah, it would be the last page of that group of pages,
Yeah.
and then the,
In here, in the front, I'm sorry, here's the front. Yes. Can you see like the little column?
On this drawing, and I'm back to, I guess, the first page, it looks like the current house is right up against the setback, the 30-foot setback.
Yes.
So this would be extending 8 feet into that, which is, fairly significant in a 30-foot setback. I appreciate front porches. Is there any consideration to making it less than 8 feet going out?
You know what I prefer, that's why we're here, yes.
Understand?
Yes.
of the other houses in the neighborhood that have porches, can you give us a sense of how far they extend out? Because I suspect anyone, since, I'm very familiar with the area. They were probably all constructed roughly at the same time, so they probably roughly had the same setback requirements. So anyone with a porch either came here, or it was a time when they didn't have to come here. But could you tell me, or tell the board, is your porch larger or smaller than the other ones in the neighborhood, or?
It is about the same size. I mean, that's what I got the idea. And I actually, when I had the architect, I asked him to go around and look at the other porches. I don't see that my, setback is like that much shorter than the others. I mean, I really do not see it, but, I don't know if it's not, at the naked eye, you can't see it. You probably have to go and measure it. But that's where we got the idea, by going around, and he actually took measurements of other ones just to see, because there is a house in the corner that is the one I'm modeling this from, that was just renovated last year.
Thank you.
Just a question. The notice does not in any way refer to the variance for the impervious. The application requests, but the notice does not. Because as you see in the plans, their impervious coverage that they want to get to is 40.8%, which is obviously above the 40%. They put in the application that they want to.
No, that,
Sorry, yeah, it is, it's just not, all right, sorry. Yeah, so again, the notice that we have in front of us only requests a variance under 283D.
Yep.
Whereas the application itself says, we are also requesting relief from 28030F. Because
Can you talk
clearly in the
about that?
plans, they're going to 40.8. So again, I want to, we have a deficiency here, first and foremost, on the notice. The second thing that I think I just want to be cognizant of is it looks like your rear yard setback, you're not in compliance with as well,
wait,
which is an existing nonconformity. I get that stuff. I just want to make sure that we're all aware of that.
The rear yard was,
no. No, Larry, it's the one about the impervious that they told you that
the
was.
impervious coverage you're
Yeah,
talking
that's-
about?
Yes, that's what he's talking
Well,
about.
our architect used the wrong numbers. And when I submitted the application, Kevin at the community,
You're saying it is in conformance?
the Radnor Township, Kevin?
When we submitted
Give
it, they
me
said
the-
was an R3 zoning, and then they said this is an R4. I believe that's what it was, right? That we put the wrong zoning, and that's why they said that we had that issue. This is an R4.
Brad.
So they told us not to come for that.
So there was the site plan had some typographical errors on it, and I recall the generalities, but not the specifics. I'd have to actually take a look at it. But the architect didn't calculate the impervious coverage in accordance with the code. And when I took a look at that, I determined that the actual property is in compliance, and the proposed renovations would still be in compliance if the relief was granted for the front porch. So there is no issue with needing a variance from impervious coverage.
Thank you. Okay, that
Thank you.
clarifies
I got a little
that.
panic there for a minute, but.
Yeah, me too,
it-
because
yeah.
So in other words, we can't say in accordance with the plans because in the application because it's inaccurate. Because we're requesting relief that we're not going to be.
Yeah, I think it would just be, if the board's going to make a motion, it would just be to address the setback issue and no other relief.
All right, thank you. That certainly clarifies that. Is there anything unique about your property? Because in what we need to look at here is you need to have a hardship to get the variance. Our ordinance are in place, so everyone adheres to it, and you generally come in front of us to say, I need this because I can't use the property without it. There's a number of reasons why you might have a hardship, other than I'd like to have a covered porch is generally not a hardship, but, I know, is there anything you can come up with? I mean, that's where we're saying, if there's a uniqueness to the property, if it's smaller than it should be, anything. Okay.
I think that's our last house before we go to the cemetery.
And I would like to have it, but.
George, I was just looking, I drove down the street today just to make sure, and I was looking at Google Maps, Street View. There's at least 8 other houses on the street that have porches like this. It appears to me that the alignment of the houses are similar to this, so they're probably all non-compliant. So it just depends on when were they constructed, did they get variances or whatever.
Yeah, I did the same thing, and I had the same reaction.
So again, I think what the chairman was asking you, so the other thing that we do is we grant the minimum relief necessary, minimum. And I'm going to say to you, I was in your same position. I wanted to put an overhead on my house. I ended up not doing it because I didn't want to get a variance because I knew I wouldn't get a variance. So I just did an overhang. So, take that at faith. So could you deal with a smaller?
If you make me, you
Well,
didn't want to come
but
either. I
again,
understand that.
you have two things that you're looking at here, is you got the length and the width. So that's what we're looking at, do you need to have it, the width, long for a certain reason? I know aesthetics is always important. It'd look weird if you had half of the house covered. There's certainly houses that just have the doorway covered. I'm more thinking about maybe the width from the house to the street. Maybe that is something to compromise on. Again, just to
Well,
give.
I mean, you want us to make it smaller?
I'm saying that
I'll just remind you, these are all questions, and we're going to decide how we decide. When people ask you, you know, can you make these changes, you can just say no. Simply as that.
Well, I would be lying because you can. I just don't want to, but yes.
That's
I mean,
perfectly fine.
I just would
That's
like
fine.
to have the porch, but
Yeah.
I understand.
We appreciate the candor.
Yes, I'm sorry.
Any other questions?
Yeah,
John?
you said you bought this house along, what, 40 years ago?
1978.
And the houses that have the porches on them now, do you recall whether or not those houses were built with the porches on, or were they added later on, or what's your recollection?
They were not, you know, with the porches. All the porches were added on later. And every time that they do renovations and they put an addition, that's when they put also a porch. Most of that, that's what they have been doing.
Okay, thanks.
Any other questions from the board? Is there any public comment? Seeing none, I'll ask for a motion from the board.
Mr. Ch-
Thank you.
Actually, we should, the deed, we should mark as A9.
Okay.
And I don't know
And-
if we,
and-
do we have to add,
Procedurally, you just ask us to accept the documents, your exhibits, into the record. So you just ask us that.
Could you please accept out my documents?
We certainly will. All right, you get the last one? Yes. Okay.
Mr. Chairman, I would propose that the board grant the relief that's been requested by the applicant in accordance with the materials and testimony that's been presented here this evening.
Is there a second?
second?
Okay, board discussion?
This is one where the absence of folks in the audience with pitchforks and torches inures to the benefit of the applicant. You know, I've known the neighborhood forever, and the porches are just part and parcel of Rockingham. So it's certainly not going to disrupt from the character of the neighborhood or cause any problems in that way. And I would support the motion.
Thank you. Regarding the hardship, some would say a front porch is always a reasonable use of property. So, leave it at that.
People that live in Harbs, I suppose, right?
No further discussion?
No, look, I'll be the first one to say, there is no hardship. Let's be clear. There is no hardship here. So if someone were to, I'm gonna make an assumption that the board approves this. If someone would disagree and take you to court, you probably lose. Just be clear. Again, people come in front of us and say, I'd like to have a garage. There's no right to have a garage, you know, and oftentimes what we do is we say, guys, what's the minimum relief necessary? Instead of a 2-car garage, they go for a 1-car garage. And you just kind of go, okay, great. So I am in favor of you doing a porch. I just don't think you should do such a large porch. That's what I'm saying, because you don't have a hardship. I know it's going to make the house better. I don't write the ordinances. I don't. And I'm here to grant variances when there's hardships. And I think we've made that clear in every single board meeting that we've had. Show me the hardship. We're going to ask Nick in a half an hour what his hardship is. And if he doesn't have one, that's what it's going to be. I am taking, I guess, a little bit now that it's not if it was an impervious variance, that would be tough. But I'm just saying, I'm okay with you doing a porch. I'm just not in favor of you doing such a large porch, because it's not allowed. That's the bottom line, so.
Any further discussion from the board? We'll have a vote. In favor of the motion, approves the motion. So, Brad, starting with you.
Nay.
John?
Aye.
John? Aye. Rich?
Nay.
I will say aye, so I approve the motion. So the application is approved on a 3-2 vote. Congratulations and good luck with your project.
Thank you so much,
Thank you.
everyone. Thank you.
Okay, the final application, appeal number 3135, the applicant Margaret and Stephen Dana, property located at 672 Church Road and zoned AC Agricultural Conservation. The applicant seeks a variance or a de minimis variance from section 280-10B4A regarding minimum side yard setbacks of the code or such other relief required under the zoning code consistent with the exhibits and testimony presented.
Evening.
Good evening.
Nick Kennelly representing the applicant. Did someone walk
Oh,
out?
sorry, here's, yeah, you can work the crowd with that.
Just by way of brief summary, this is a 100-year-old home in the Agricultural Conservation District. In this district, the requirement is that you have side yard setbacks of 50 feet. Interestingly, you'll see that this backs right up to the R2 district, actually, where there's much less requirements. I believe it's a 20-foot requirement in R2, and even R1 has a 25-foot requirement. But because this is in the AC district, even though it's a non-conforming lot, as to lot width and lot area, they are required to comply with the 50-foot setback. Since the house is 100 years old, there's nonconformities, and we'll get to that. I've made copies of the code regarding the side yard setback. At one point, the requirement was only 25 feet. It was increased to 50 feet in 1981. The house was built prior to 1981, and it was built 32.3 feet from the property line. This proposal is only to move it 2 feet closer to the property line. The purpose of it is to construct a master bed, master bath, living area on the ground floor because of the disabilities and age of the occupants and the desire basically to stay in Radnor. So if we can, we'll swear in the witnesses. Norma, please.
Oh, yeah. I do.
Margaret, M-A-R-G-A-R-E-T, Dana, D-A-N-A.
Stephen, S-T-E-P-H-E-N, Dana, D-A-N-A.
And Stephen, you're up. Are you the owner of the property? Okay. Are you the owner of the property with your spouse?
Yes, we both.
And
jointly.
how long have you lived there?
Moved in July of '99.
And
so it's 23 years.
in addition to your house, to your wife, who else has lived there with you?
Our son grew up there. He is now an adult and out of the house, but he was there for, gosh, 17, 18 years.
Right, showing you A2, this is the deed to the property indicating you acquired it on July 15th, 1999.
Correct.
And then A3, is this an aerial view of the property showing 672 Church Road?
Yes, yes.
And just for, by way of bearings, Conestoga Road is at the bottom or at the top?
It's up here.
It's at the top, okay. So Conestoga Road would be up here in Cantera, and actually the property right adjacent to you, which we'll show on the next photograph, is actually zoned R2 residential, correct?
Right.
And on A4, this is a map of the Radnor Township zoning map, and 672, that's your property with the red star on it?
That's correct, right.
And that's just the beginning of the AC zoning district?
Correct.
And the green that is shown there, that's the R2 district.
Okay, right.
And I believe the board is aware that the R2 district has, I believe it's a 20-foot setback requirement. R1 actually is only a 25-foot setback requirement, but since this is zoned AC, you know, there is the 50-foot requirement. I'm going to show you what's been marked as A5, and is this a site plan prepared by John Smirga, professional engineer?
Correct, that is
Okay,
right.
yeah. And remember, you have to respond.
Right.
And
And he's
this-
overlaid it on the
Right.
the house and the, sorry. Okay. And John has laid out the property based on the survey, and then the house is overlaid and the addition is in that section.
All right. What's the age of the home?
Built in 1920, so that would be, gosh, 102.
Okay, but actually that's
No.
prior to the establishment of a zoning code in Radnor.
Right.
And we can take notice of that, judicial notice. And you wish to construct an addition to your home, correct, as shown on the plan in this area, which is the crosshatch area?
That's the added portion. Actually, we're putting the handicap better. My wife has Parkinson's disease, and so we live in a 3-story home, and we live on the 2nd floor now, but it just would be a great advantage to be on 1 floor as her condition progresses, as it likely will. We're taking a room that is now a family room that's in this area, and then making it into a handicap bedroom so that this portion is a bathroom and a little breakfast area.
Right. As to the plan itself, I mentioned in opening that it's non-conforming as to lot area. This is the required lot area is 2 acres in the agricultural district, is
Yes.
my understanding.
Mhm.
And actually, we're 64,498 square feet,
Right.
which is about 1.5 acres, I think.
Right.
Or,
It's
correct, 1.5 acres.
below the amount. Yeah.
Right. And also, as to lot width, the requirement in the AC is 180 feet, and yours is 150.
150, right.
And as to the one side yard, you're in compliance. It is 50 feet. Is that accurate?
Correct. And just right along the outside of the house, the patio is, I guess, not in compliance.
Well, it's not a structure.
Correct.
Or a building, I should say.
Yeah.
And as to the side where the addition would be going, the existing home is 32.5 feet from the property line? Is that right?
That is correct, 32.5, and I think you may have photos that would show that. But this is a breakfast room that was added by the previous owner, and this is the back entrance, and we want to make that wide enough for handicapped entrance. And then this is the addition, which is basically 9 by 21 in length.
And again, if the board could take judicial notice of A6 and A7, A6 shows the Radnor zoning code in 1978, which required 2 side yards with a minimum of 25 feet and an aggregate of 60, which would have been compliant at that time. And then the code was changed in 1981 to require the 50-foot side yard setback that is the requirement today. I'm going to show you several photographs now to orient the board to the project. First, A8. Can you tell the board what A8 represents?
This is the entrance to the home. Church Road is right here in the front.
At the bottom of the picture?
The bottom of the picture. And then this is a driveway, and it circles around. We have a gate over here as well. And as you look in, this gives you the total picture, but you can see the breakfast room here on the right of the house that is already in place, was added by the previous owner.
And the only relief you're asking for here is the side yard setback. Is that right?
Correct, yes.
Yeah.
Yeah.
You're not asking for any impervious coverage or?
No,
anything
no,
of that
no.
nature?
It's actually, the addition just has a breakfast room. The driveway continues back. There's a garage and there's a parking area, and there's a brick path. So the new addition covers over a little bit of the already laid down pervious cover of the ground, impervious cover.
And A9 is just a closer view of what we were looking at previously?
Correct. And looking same view, head back, but it does give a sense of the neighbor who is right here.
In front. The neighbor's located, neighbor's
Slightly
building's in front of
Slightly,
your house.
yeah. Mhm. That's the back of the house. This is the patio area, just to give you a sense of what this looks like. It's, I don't know if this is interesting or not, but interesting to me is a concrete house with stone cover. It's very solid.
And the addition would be to the left of this photo where?
This is the area that is now a family room, and the addition would be, this is where the bedroom would go, and you'll see a picture later on, or a rendering that will indicate what the extension would look like on the other side, the driveway side.
And A11, that's just another photo of looking up, and again, it shows the house, the
Correct.
neighbor's house a little more
Right.
clearly. And then A12.
This is just looking the other direction, but gives you a sense of where the addition would come out. This is the family room, the other side that we just looked at from the patio. And the new portion would come out in this direction. There is a breakfast room, and the addition will come out about 2.5 feet beyond the breakfast room, but there's also a wall back here. I'm sorry? Okay. There's also a wall back here. It really doesn't go out maybe a foot more than that wall.
And you're not going to extend or widen your driveways?
No, there's no need to. There's plenty of room to come through and drive and park. And so, no, nothing to do there.
A13?
That's just a little closer view of the area, and this is the back entrance currently. We will continue to have the entrance there, but we'll be widening it for handicap entrance capability. Also gives you a sense of the breakfast room.
Would the bathroom also be handicapped accessible?
Yes, that's another part of the reason we don't have a handicap bathroom except accessible for handicap in the house. All the bathrooms are upstairs except for a powder room on the first floor, but no shower or anything. So we will be adding a bathroom. That's what the 9x21 is going to encompass.
A14?
That's just another close-up of the area that we'll be punching out, basically, in this direction. I took a lot of pictures saying the same thing. But then this gives you a sense of the back entrance. And here's the wall I mentioned that will be kind of in line with the building coming out.
Again,
Yeah.
A16, I don't think we need to
No.
go through that. Another picture of the area. And then A17, want to describe
this? Right. This is the architect's rendering of what the house will look like when it's been completed. And I think the point of comparison of interest to you both all is, again, this breakfast room punching out, and then this is the new addition punching out a little bit farther.
Have you spoken to your neighbors or contacted your neighbors
I
regarding
sent,
this?
what I did was I sent a letter with an explanation of what we're going to do. I sent them this photo and 2 other photos to show the area of the construction. Those are the neighbors that are on the perimeter. There are 8 people that I sent letters to with the photos, and 4 have responded favorably. The others have not said anything, and I'm not sure if they have any comments, or maybe they're not home. I don't know. Get the mail.
And you also sent the mail, the township required mailing in addition.
Oh, yes, right, yeah, 85 letters. That was a good project.
All right. That's all I have at this time.
Yeah. So, sure.
I'm looking at A16, if you have that picture. That might be the best way.
Yes, sir.
So that existing, I think you said it was a breakfast nook that's right in the front of the picture there?
Yes, the kitchen is right.
Got it. I'm sorry, is that being punched out also?
No, that I was just using as a reference point.
Oh, okay.
You see what's already there, and the new one will
Yeah,
not
that's what the
different.
sketch looked like.
Okay, yeah.
But then I was looking at the schematic here, and it looked like there was something added right there on the drawing on A5. And maybe I'm just looking at this
Well,
incorrectly.
The back entrance is.
A5, yeah.
A5.
Yeah, it looked like there was something added there.
I'm sorry. In this, oh, I see what you're saying. Yeah.
Is that a sidewalk or something, or?
No, there's a stone wall to the left
Yeah.
of the breakfast room.
Okay, but so
Yeah.
that's not an add-on, that's just.
No,
something that's there
no.
now.
That is actually the driveway line that you see going
Okay,
out.
all right.
You know,
Understood.
There's some plantings there. Yeah.
All right, thanks for explaining that.
Sure.
I just have a quick question. Is the proposal, I'm going to look at A16 as well.
Sure.
There's just it looks, you said a wall, and that's what
Yep.
it looks like.
Yep.
Is the addition going to extend past that wall?
About yes. It will be roughly 2.5 feet. Actually, it's 2.5 beyond the breakfast room, but 1.5 feet beyond the wall. The wall goes out beyond the breakfast room.
And is there significance to the 9 feet wide?
That was what the architect really felt was necessary to have the handicap adequate bathroom. That's really it. Mhm.
So I'll ask the question. Nick, can you explain the hardship?
Sure. First, we have a lot that is non-conforming. You have a lot that's non-conforming as to the lot width and as to lot area. Probably more importantly, in this case, it is non-conforming as to the lot width, particularly since they changed the requirements in the Agricultural Conservation District from the prior 25-foot requirement, which is plan complied with, to the 50-foot requirement. Also, as far as hardship is concerned, we do have a handicap situation, which is covered by the Fair Housing Act, and reasonable accommodations have to be made to accommodate a handicap situation under the Fair Housing Act. Additionally, we have a situation where we're only asking for relief of 2.5 feet, which is what I would consider to be de minimis.
Any questions from members of the board? Any comments from the public? Seeing none?
George, may the exhibits be made part of the record, please.
Thank you, Nick. And they've all been marked.
I forgot that last month, so that's...
Yeah, they're still hanging out there somewhere. I'll ask for a motion from the board.
Mr. Chairman, I would move that the applicant be granted the relief requested in its application in accordance with the plans and testimony provided here this evening.
Is there still a second? Okay. Any further discussion, the board? Okay, we'll have a vote. Brad? Aye. John?
Aye.
John? Aye. Rich?
Aye.
And myself, aye. 5-0. The application is approved. Good luck with your project.
Thank you very much. We really appreciate it.
Thank you, guys.
Thank you all.
And meeting's adjourned.